Good afternoon, and thank you for checking in again. I am attorney Peter Angelis from Detroit, Michigan. This afternoon, I wanted to talk a little bit about alternative dispute resolution, or ADR, procedures that we have here in the state of Michigan. ADR stands for, it's a generic term, but it could stand for either mediation is a form of alternative dispute resolution, facilitation, which is very akin to mediation. We have a mandatory case evaluation process, which is part of the state court system's ADR effort. There's also a binding arbitration that the litigants can agree to. So I want to touch a little bit about the ADR options that litigants have. Let's start first with case evaluation. Case evaluation is a mandatory court-ordered process that is ordered after the close of discovery. The case evaluators are chosen by the various circuit courts. Every case goes through case evaluation unless there's some equitable issues involved. If there's equity involved in the case, it's not appropriate to go through case evaluation because at the end of the day, the case evaluation panel, the case evaluators will be issuing a number, an award, a monetary award of what they believe the case should settle for. And that's based upon a number of factors. There'll be a legal brief that's filed by the litigants. They will meet with the plaintiff and defense attorneys together in either a Zoom meeting or in-person meetings. Each side will present informal arguments. And then the case evaluation panel speaks with the attorneys separately to find out what they're willing to pay, what they're willing to receive to resolve their case. And at the end of the hearing, the case evaluators issue a case evaluation award, which is their thought process or what they believe the case is currently worth for settlement purposes. The awards are usually unanimous, and once the awards are issued and served upon the parties, the litigants have 28 days to accept or reject case evaluation. Recently, the court rules have been revised. There are no longer any case evaluation sanctions for rejecting case evaluation. So that has really undermined the significance of the case evaluation process. And what we're seeing is a number of litigants opting out of case evaluation and agreeing to participate in either a mediation or facilitation process in lieu of case evaluation. That seems to be the trend now, to submit cases to mediation. And I know that is pretty consistent with a lot of other states. So let's focus a little bit about the other ADR options, starting first with facilitation or mediation. Both ADR options, which I consider to be relatively interchangeable, and let's refer to them just as mediation. First important thing to do is to hire a neutral mediator that everyone can agree on and that everyone has respect for, and somebody that knows the subject matter of the litigation, the type of law that the case involves, either auto negligence or insurance work or physical damage claims. Get a mediator that has been around the block a few times, that knows the judges, knows the attorneys, understands the subject matter. And so that's the first step. You agree to an agreeable mediator. That mediator will issue a pre-mediation set of instructions in terms of when the brief will be due, how the mediation will be conducted. And then usually the mediation, you're going to want it to be done at an appropriate time. So you have to give some thought as to when you're going to schedule your mediation. You obviously would like to do it after you've received discovery from your opponent. You want to do it at a time close to the end of discovery or after discovery has been completed, so that everyone participating in mediation understands the case sufficiently to make informed decisions. If there's a lot of loose ends in terms of who's going to pay the settlement, or all the medical records have not come in yet, conducting an early mediation is not going to be successful because there are just too many question marks. If there's a liability defense as to who's responsible for the accident, it's going to be important to take a few depositions of the key eyewitnesses so that the litigants understand what they're up against. The mediator will conduct an in-person or remote mediation, where again, both sides will get an opportunity to make a presentation. The clients do not have to testify. There's no testimony taken. I should say that a lot of times at mediation, the clients do appear, and it is good, I think, if you're an insurance adjuster on a big case, to appear personally. But we're seeing more and more things done remotely. So that's kind of been the trend to do things remotely. So after the mediation, if it's successful, the mediator will get everyone to sign a mediation settlement that will be contingent upon either court approval if that's necessary, or the exchange of a release and acceptance of a release and payment of the settlement. And mediation's been the way that almost all cases are getting resolved now, short of trial. The final option I wanted to talk about is the arbitration process. Arbitration is basically like a little mini trial. Again, it is done contractually. It's an agreement that you have with the opposing side. The court loves when you agree to go to arbitration, and they'll agree to give you an adjournment of any deadline dates because you're going to arbitrate the case. Once you enter into an arbitration agreement, and I should say the arbitration agreement should be in writing, specifically laying out the rules that you're going to follow during the arbitration process, and also laying out the obligations of the arbitrator. The rules of evidence are usually relaxed. You'll agree to submit medical records without a records custodian, things like that. And then during an arbitration process, again, the arbitrator will send out a letter, a scheduling letter indicating the date of the hearing and when the legal briefs are due. Each litigant will file a legal brief summarizing the case and the law and attaching a few exhibits. And then a arbitration hearing will be conducted. Used to be always conducted in person. Now more and more they're being conducted remotely. And during the arbitration process, the attorneys will again make a presentation to the arbitrator, like an opening statement. And witnesses can be called during the arbitration process and sworn by the arbitrator. At the close of arbitration, and usually within a time frame agreed upon by the litigants and within the arbitration agreement, usually within 30 days, the arbitrator will issue a written award. This written award is just like a final award of a jury or a judge. And that award can be taken to a circuit court if necessary and entered by the circuit court and enforced through the court system. That award of the arbitrator is fully enforceable and finalizes the case. It's a final disposition. The only way to get around an arbitrator's award is if there was some type of fraud that was committed, or if the arbitrator exceeded his or her authority under the arbitration agreement. Arbitrations usually can resolve a case within 6 to 9 months. And then waiting for trial sometimes now in Michigan is coming up to around 2 years, and sometimes even longer than 2 years. So I've participated in all aspects of ADR over the 35 years. I've sat as a case evaluator in Wayne County Circuit Court and in Oakland County Circuit Court. I currently sit in both circuit courts as a case evaluator. I've sat as a mediator, and I have also sat as an arbitrator. Similarly, in my practice, when I'm representing clients, I've been involved in case evaluation, mediation, or arbitration. So I highly recommend ADR as a way to resolve cases efficiently. Our office, in appropriate cases, will recommend one or the other. The courts are definitely going to make you go through some type of ADR, mediation or case evaluation, because the judges like to see these cases resolved short of trial. It would be impossible for the courts to take every case to trial. So that's something to think about as you're litigating your case. Again, Attorney Peter Angelus, I appreciate your attention. Thank you.